before you got here, we signed an agreement hoping that you would be able to take a look at this.
Yeah, I'll do that. How can I say no when I'm late myself? Sorry about that, busy morning. So, couple things on the plate today. The old business on those, Jen did send me the legal for the can, which was different than the one I had, although the confusion about it again is it's 7.4 acres. So, but anyway, we just sent off a letter to the state, see what kind of response they're going to give us. And then the next step is just to execute the deeds, get them recorded. But I mean, we've got to dispose of the properties. We've got to know who we're going to deed them to. The state on the one property has a right of first refusal. On the other, a right of refusal. So if they say it's okay, then we can sell it. If they say it's not okay, then I say we just deed it back to the state. And what else to do? Sort of a state. So, but anyway, their guy there has the letter now, so we'll see how they respond to that.
So, and that is, part of that also is the part that we're going to turn over to the township, or? We have, that's our buyer for that, right? We're going to just give it to them. I'm assuming they're not going to have any argument with that. It's the camp thing that I don't know what they're going to say. And that one, I know that the language is different in the deed. It doesn't say, it puts all the conditions in the deed, but it doesn't say they have a right, that they can give up their right of first refusal on taking it back. I don't know if that's good for us or bad for us. We'll see how they interpret that. But anyway, they've got it, so we'll see. So that's finally in their hands. I need to talk to you about this Bickle case. You need to bear with me on this. This gets a little complicated. But it's, we got a letter from our prior insurance company, CNA, on this, November 22nd. This actually went to Mark, but I got copied with it. Mark sent it on to me, and it gives us the status of the lawsuit, so you have the status of the lawsuit. And I'm going to go over historically a little bit of what's occurred in the lawsuit. So, and there's really nothing for you to do today, just to know about this, and I'm trying to bring them to date on it. Originally, this lawsuit was brought by a man named Bickle, who's alleged that he was over-detained, awaiting arraignment on charges. Under state law, you need to be brought within 48 hours. The judges here basically control, even though this is a claim against the sheriff, the judges are the ones who have basically control when prisoners are brought before the court for arraignment. And over the course of time, the way, and I can't explain to you the exact procedures, but there were a number of occasions when prisoners were brought after the 48 hours based upon the business of the court and the instructions of the court. So, and the reason I'm telling you this is I see this as just a circumstance. There's a lot of other counties involved in this. This is no way the sheriff's fault. The sheriff just did what he was told. Unless we're on the hook. So, or maybe. So we get to notice from Bickle's lawyer. Well, then Bickle's lawyer decides to make it a class action, and there are actually, and I did not really know this until for sure today, but 243 members of this class are people from Whitley County, prisoners, who were brought before the court, let's just call it too late per the statute. Now, some of these may have been 2 hours, some of them may have been a half a day, some of them may have been 26 hours, but they're all in the category that they're beyond 48 hours. So they're all part of this class, which is in federal court is a violation of civil rights, is a basic action. So the county has lost on liability. In essence, the court, the federal judge, and this, I told you this has been news about a year ago, but the judge decided that the statute was violated, and therefore the issue left in this case is damages. Okay, and one can
and ask yourself, what are the damages from somebody who is going to be in jail anyway for a criminal act? And you would have to sort through case by case to really figure out what damages are. Many of these are minimal. I think I've expressed this before. Possibly all of them are minimal in terms of what a jury might award them. Nonetheless, there's 243 of them, and if you paid them each $1,000, you get the number game. So now we've got this letter from CNA, and since it's become a class action, obviously that means a number of these people in the class, their arrests were at various times through the years. That means that there may be various policies covering various people. CNA has put Travelers on notice. Travelers has said, no, this all occurred before us. But there is an issue of when coverages overlap. And this is before CNA and after CNA, all right? So it becomes a highly complex insurance decision who has coverage on which members of the class. All right? This is a lawyer's heyday, all right? So, as of yet, nobody's filed anything. None of the insurance companies have filed. It would be a declaratory judgment action. Nobody's filed anything. The main case, as to the disputes between the insurance companies, the main case on Bickle and the class is going to be mediated this Thursday. I just found this out in this letter. We haven't been noticed of this. You haven't asked to be there. And you shouldn't be there because we don't know enough about this for anybody to be there. The upshot of you not being there is you wouldn't have anything to offer to pay in this case, which you wouldn't anyway, I'm supposing. So it'd be a waste of time. So right now, I talked to CNA's lawyer this morning. She says she doesn't know what the position of the plaintiff's lawyer is going to be. Right now, he's over the amount of their insurance coverage, which is $1 million. Whether he comes below that, she doesn't know. I don't know. Probably he will. And we hope he does, because if CNA settles the case, we're done with it. Right now, CNA, to further complicate this, they said, we don't have coverage for this stuff for you, county. And that's why I'm advising you of this whole thing, because at the end of the day, there is not a probability, but a possibility that the county could be liable for whatever if the case went to trial and there was a judgment and then CNA won their coverage, which they haven't even filed a coverage dispute claim yet. But if they did, worst case scenario, the county could be held liable without any coverage for this case. So, highly complicated. I think I've given you, I had talked to John Lefevre. CNA has not kept them in the loop, so they really don't know what's going on. CNA's still looking around to see if there's other insurance coverage or insurance policies that predate them. There are some, whether or not, and John told me that Cincinnati was these policies are underwritten by others then, and so they've made inquiry, but Cincinnati hasn't responded yet to determine which particular companies are involved. So I apologize for that lengthy description, but that tells you kind of the lay of the land. From a legal standpoint, it's very interesting. Hopefully, it can be resolved in mediation. The lawyer indicates to me that CNA wants to resolve it, meaning they'll pay some money. Whether they'll pay enough to satisfy the plaintiff, I do not know. That is that.
But that would just be Bickle, or
All members of the class.
Okay.
All members of the class. But again, the lawyer cited to me a case that had been tried last year by one of her colleagues where the plaintiff won $300 for this. Juries typically, and I don't want to prejudge it, but typically juries are very impressed by defendants and prisoners who bring these kind of actions, and there's not a lot of success in the courts. But in this case, they've already gotten over the hurdle of liability, so there's exposure of some amount.
This same conversation, I think, is probably going on in LaGrange County and Allen County and,
That-
right?
Yes,
Wasn't this
correct.
sort of a northeast Indiana kind of thing?
Correct, and I haven't talked, I'm gonna call, I know the lawyer from Allen County that's handling this, I'm gonna give him a call this week and see what their status is. What the lawyer from CNA told me, she says one of the problems is she thinks one of the counties is folded and paid, one of the county's insurance company folded and paid the plaintiff their money. And so that emboldened them, you know, now that they wanna try to get that from every county, so. It's, we'll see, but hopefully, we'll get some good news after Thursday, we don't have to worry about it. I kinda feel bad for Mark, he didn't do anything. I mean, if we had brought him to court and the court was busy, I mean, it wouldn't have made any difference. They wouldn't have been arraigned, so, that's that. And I mean, that's all I have. I did, you know, you talked about my contract for services the last time, and I brought a new one that I can leave with Jen, you guys can review it, it's the same.
Good, thank you.
Yeah.
Do you have anything for the?
I
Make it
drove
easy for
80
you.
miles for this, 80 miles an hour. That's my life.
Appreciate your help with the employee luncheon.
Oh, yeah, that was, I
And you
forgot
are
to ask.
invited, by the way.
Oh, great, what's the date on that?
The 13th.
All right.
It's Friday the 13th,
Friday
in
the
case
13th.
you want to
11
make a
o'clock,
note
11
of that.
Well, I'm happy to do that, they deserve it,
Thank
so
you.
I hope they have a great time, and I hope I make it enjoyable.
We'd like to have you.
Okay.
So on this thing to Thorn Creek, then we have to wait till you hear from the state, because another reason I asked, Gene Heckman's kind of been after George and I to, because he wants to try to get this well, if it's okay by him and everything in this year's budget.
Well, if, I think we can get it done by the end of the year. I'll do the deed and you guys can sign it. I hesitate recording it because if the state comes back and they say, no, we wanna keep it,
Yeah.
then we're in a kind of a pickle. But everything is in place now to
Well,
get
he
this
just
done.
wanted an answer, he could,
Well,
I would suggest, and Jen, you can help me if I'm wrong here, I would suggest that if he knows who he wants to have the well done by, to establish a contract, and then, because he wants to use this year's money, right? Then he just encumbers that money. It's a very simple,
he can
simple
encumber it,
process.
as long
He
as
can
he's
encumber
got
it, and then
I
he
did
can spend it.
suggest that to him, he said that could be a possibility.
Okay.
He could work it in next year's budget, would be a little better for this year's budget.
But he can do it this year, I mean, he
But
can do it.
by the time, by the time you get a well company, say, submit a bid, they're going to have to go to IDM, what hoops are they gonna have to jump through? Do they need certain piping, certain pump and everything else? And, in fact, IDM might come up and look at it.
well,
That's,
yeah.
and they don't jump, you know, and you're looking at Christmas holidays and things, and, but that's the only reason I mentioned, at least we have a answer if he calls you.
You know, and the state may not even respond to me. I gotta be honest with you. I've had a number of communications with the state on this, and it isn't, I send a letter one day and 5 days later I get a response back. I mean, sometimes I get none, sometimes I send 2 letters, so I'm not gonna promise you that this is gonna be resolved quickly. I hope it will be.
I think it puts them in a pickle too, because they really don't want it back.
They do not want it back. I have to believe, and I always get in trouble when I say this because it turns out different, but I have to believe that this will work in the long run.
Okay.
Yeah.
Thank you, Dan.
Okay, thank you guys. Brandon, you got something I need to look at, is that, did they say?
Yeah.
Yeah,
Okay,
I can email it to you.
great. Email it to me. I'll look at it today.